Good afternoon, everyone. My name is Stephanie Bryan. I'm a Senior Associate here at Michael Lynch Family Lawyers. This afternoon, we're going to be speaking about counselling, confidentiality in family court matters, and also a little bit about the recent court merger, which you may have heard about. It was as of the 1st of September this year, so it has had a little bit of media attention around that court merge as well. So I'll just give a little update about where we're at with those things. So a little bit about the firm. We are a specialist family law firm that's been in Brisbane for 25 years this year, actually. We have 13 lawyers, 6 of who are accredited family law specialists, and family law is all we do here. So, there's other firms that might practice in other areas. We really are only focusing on the family law side of things here. We offer, obviously, advice to clients. We do client work, court work, that kind of thing. We also publish a lot of material on our website and produce info sheets and flyers, which we can send out to you guys if you do want, or you can also access a lot of information on our website. We do a fixed fee initial consultation, which may be something often as counsellors, you guys might have clients asking about where they can get some family law information. So you can, we do a fixed fee consultation. There's no obligation for the client to engage us beyond that. So if that's something that clients of yours are needing, we can offer that service as well. So that's a little bit about the firm. We're located in the city, so if you are wanting advice, but particularly post-COVID, I guess we're all very used to now doing advice through Zoom, telephone, all those kind of things. So we offer those services as well. Okay, so just a little overview about what we'll be talking about today. We'll talk a little bit about family dispute resolution and family counselling, and that's, I guess, defined under the Family Law Act. So it's not just a general term, that's a specific definition. We'll talk about confidentiality and admissibility. So when we're looking at that, we're looking at counselling notes, what happens with counselling notes when there's family law proceedings involved, when you may be asked to provide evidence in court proceedings, whether that's written evidence or giving oral evidence in a trial. I'll talk a little bit generally about parenting arrangements terminology that might be used, because I know counsellors often come across court orders or parenting plans, or people are using words that they may have heard from their lawyers. So we'll talk through generally a little bit of the parenting arrangements, the process, and the court process, and how that all kind of ties together, and the different points that counsellors may be involved. And then, as I mentioned, we'll also just chat a little bit about the most recent court merger that's happened and a bit of an update about where things are at. So what is family dispute resolution? So I'm sure some of you are either family dispute resolution practitioners, or you may have heard clients or other people talk about family dispute resolution, or FDR is often how we abbreviate that. So that's a process where the practitioner assists the party to resolve the issues around separation and divorce, and parenting arrangements in particular, I guess, is what often that's used for. So FDR practitioners must be accredited. So that's when it says FLA, that's obviously referring to the Family Law Act. So those are sections under the Family Law Act that really define these terms. And with parenting matters, it's compulsory to attend, or at least attempt to attend, an FDR session prior to commencing court proceedings. So that's called a Section 60I certificate. So that certificate would say whether the parties attended, whether one party tried to attend and the other party refused, or whether it was not appropriate for FDR. So the usual exception for when it may not be appropriate to do FDR is if there's domestic violence involved, because obviously that has other issues. Parties may also be able to get an exemption from doing that FDR process if there's some kind of urgency involved in the matter, or some other really serious issue that the court needs to address much more quickly. So that's when we may see FDR coming up. We've also got family counselling, which is just defined separately in the Act. So that's the process in which a family counsellor helps parties or children with issues relating to the marriage, separation, divorce, or the parenting arrangements. Again, that's defined in the Act. And again, that person that is providing that service has to be authorised under the Family Law Act. And there's actually a website, a list produced by the Attorney General's Department as to who is authorised under that section. So that's quite a limited area. That's obviously separate to other people who might just be providing private counselling to people and are engaged privately by people. That's kind of a separate category of counselling. Do you have to tell a client what the Family Law Act says? So there's if you fall into one of those very specific categories of family counsellor, advisors, or family dispute resolution practitioners, the Family Law Act does provide a number of things that you are required to tell clients or parties coming to you for those services. But again, this isn't necessarily the same if you're just providing private counselling to someone outside of those categories. So an advisor is compelled to give advice to parents about the fact that they need to have regard to the child's best interest as the paramount consideration, encourage parties to really be child focused when they're making decisions and using that best interest of the child, while also having regard to any need to protect a child from physical or psychological harm, and we'll go through these principles and where they lie in the Family Law Act when we talk through the parenting arrangements, but also the benefit to a child of having a meaningful relationship with both of their parents. So as an advisor, so as a lawyer, this is something that we have to tell clients when they're coming to see us, but if you're falling into those family counsellor or family dispute resolution practitioner categories, there's also an obligation under the Act to notify clients about that. Under Section 63DA of the Act, you also need to inform parties that they can consider entering into a parenting plan and where they may be able to find more information about that process. So often what happens at an FDR is if parties have been able to get some kind of agreement, they may decide to document that into a parenting plan. And you have to obviously tell them about the parenting plan. And as part of that, you're probably going to be saying, well, your parenting plan should be made having regard to the child's best interest. So you can usually cover all of that off in the same kind of discussion if you are. You also must inform parents that an equal time arrangement is an option. And again, this is the process that the court goes through. So it's kind of summarising that for people. Equal time arrangement is an option if that's in the best interest of the child and if that's practical, and then if not, significant and substantial time between the child and the non-resident parent, and how that's going to be included in a parenting plan. You should also be telling parties if there are already court orders in place, if they do enter into a subsequent parenting plan, then that parenting plan can override that court order if there's any discrepancies in those. So it's just, I guess, important to tell people before they're entering into a parenting plan, just to make sure they're aware of what consequences that may have on any other court documents that they may have, for example. And also providing them with information about the availability of services and other courses. So there's a lot of post-separation parenting courses, triple P parenting courses, court order, courses about how to implement court orders. So there's a lot of services provided by people like Relationships Australia, and so just notifying people where they may be able to get more information about those kind of things as well. Obviously, as counsellors, you would know that you have certain notification obligations. So that's what you might refer to as like mandatory reporting. So if a child has been abused or is at risk of abuse, you obviously have to comply with various Commonwealth or state legislation in relation to reporting that to police, child safety, for example. So anything that we talk about today does not override your usual obligations to mandatorily report those things that may come up. So just a caveat on that. So I guess what we're talking about today is what communications may be made during family counselling and family dispute resolution as they are defined in the Act that we've just spoken about there. So communications made during family counselling or FDR are confidential and inadmissible unless an exemption applies. So in family law, there's a lot of areas where the answer to a question is it depends, or unless an exemption applies. So that's just something that we have to, I guess, deal with as family law practitioners. It's very common that there's no black and white answer to some of these questions, and this is one of those that exactly the same with this area. So the general rule is confidential communications and inadmissible unless an exemption applies, and the sections of the Act do quite helpfully set out what those exemptions might be, and they're listed there, so it might be worthwhile having a copy of those or looking at a copy of those if you do have this question come up. So you must not disclose a communication made in family counselling or FDR, but again, that mandatory reporting obligation, so you must disclose it if it's in compliance with another piece of legislation. And then you may disclose it. So that means it's discretionary and up to the practitioner if both parties consent, if the disclosure is necessary to protect a child from harm or to report an offence or to assist the independent children's lawyer. So I'm not sure how much court work the people that are linked into the webinar do, but an independent children's lawyer would have been appointed by the court if a matter is involved in a court proceeding. The judge can appoint an independent children's lawyer who's there to represent the child's best interest and to act on their best interest. So not acting for either mum or dad, but acting in the best interest of the child. So you may disclose it to the ICL if you think it's relevant and necessary. So that's confidentiality. That is, I guess, a separate question to whether material is admissible. So confidentiality is whether your notes can be disclosed. Admissibility is, I guess, how the court can use that information. So that's really a question that comes back to the judge and the court. So that's not necessarily, and the parties, probably legal representatives if they're involved in that kind of court process. So again, communication during family counselling and FDR is not admissible, exception again if there's an abuse or risk of abuse under those sections of the legislation. So I guess there is a little bit of a conflict. So even if you decide that you do want to disclose it because it may be disclosed because, for example, to assist the ICL, the parties and the judge may still have an argument about whether that information is admissible in the court proceedings, but I guess that's not necessarily a matter that you as a counsellor would need to worry about. So evidence of things said with a family counsellor or practitioner during family counselling or FDR is not admissible. Again, there's I guess some exceptions to that, including if there's an admission by an adult of child abuse or if a child is discussing abuse, unless the court thinks there is sufficient other evidence of the admission or disclosure. So I guess this is really an indication of how the court does want to protect that therapeutic relationship. So if there is another way, for example, if there's police records or school records or the child's made a disclosure to child safety or something like that, the court prefers that evidence to relying on notes from counsellors or FDR, because the nature of a family counselling and an FDR relationship is that it is confidential, because that gives people confidence in that system as a counselling system or in that system as a way to resolve a dispute without being concerned that that information is going to be used against them in court. So there have been, I guess, some cases that have been taken to the court where there's been some, I guess, dispute around the application of some of those sections. So there was a case by Uniting Care looking at this section 10D about that issue of when a counsellor may disclose information, and the court said that, the discretion really remains with the family counsellor whether to disclose that information, even if both parents consent and if the court directs. So just because the court says, I want that information, the sections of the legislation really say that that's ultimately up to the family counsellor, unless it's one of those mandatory exceptions. And again, even if the communication can be disclosed, it's not necessarily admissible unless it's that kind of risk of abuse or that high level of risk. Obviously, the court has to be conscious of, again, breaching that therapeutic relationship, but obviously the need to protect children is really at the forefront of the court's mind. So if there is a need to protect children from that, they need the information they can to make a decision about those things. There was another case, which was the Baden Clay case, which I'm sure everyone has heard about. These sections only relate to the family law jurisdiction. So that, I guess, we sometimes see matters where there's cases for domestic violence, or there's other civil cases or things like that. So just because it's confidential in a family law setting doesn't mean that extends out to other cases that may be related. So I guess it's really a case by case. It's important to get particular advice if you are faced with one of these issues about whether the notes should be disclosed. There are different rules that operate in different areas, so it's just important not to just assume that the same thing is going to apply across the board. As I mentioned before, at a family dispute resolution, often the outcome of that may be that the parties agree to a parenting plan, and we'll talk a little bit more about a parenting plan later on and how that may come about, but that is often what comes out of an FDR. That parenting plan is not confidential because obviously the parties need to rely on that parenting plan to show to the court what they agreed, to show to the court what the arrangements are, to make sure that everyone's on the same page. They might need to provide that to the school, for example. So that's not confidential. So yeah, if an agreement is reached but it's not actually documented into a formal parenting plan, then that doesn't get around that confidentiality element. It's really got to be in a parenting plan. There's no strict format for a parenting plan, but if it's written, signed, dated by both parties and has been made without duress, then that means it's a parenting plan. That means it's not confidential. If it's just a verbal agreement that they've reached, then that can't be disclosed in the court proceedings. And the content of FDR is not admissible either. So you can't have a discussion about what happened during the FDR, who said what, who made what offers. That's the whole purpose of an FDR, is to be that confidential space for parties to be able to have a discussion and try and resolve issues. So that's FDR. Family counselling. Again, as I mentioned, that section really defines that as a specific class of accredited counsellors, and the list is on the Attorney General's site, so it doesn't just mean any counselling. It has to be counselling directed to the parents' relationship and breakdown. So it's not about, I guess, different category to family therapy or anything, or that private therapy for one parent. So one of, I guess, the big questions that may come up for counsellors is how they may be required to give evidence and when they are compelled to give that, as opposed to when it may be voluntary. So there's a couple of ways this may come up. So you may be served with a subpoena, which requires you to produce, for example, a copy of your notes. You may be subpoenaed to actually show up at court and give oral evidence. You may be asked either directly by the parents or from a family law solicitor or some other person involved in the matter, or the ICL. You may be asked to give a report, and that would then be attached to an affidavit to be signed by you, and that would usually include something like your CV or your resume, something to show your qualifications, because the party's kind of holding you out as an expert in that area. And this is the same, I guess, for both family law and domestic violence proceedings. Just keeping in mind that the sections I referred to earlier relate to the family law side of things and not so much the domestic side, violence side of things. So if you receive a subpoena, that's actually, I guess, that's compelling you to give this information. That comes from the court. The court has made that, and you're required to comply with that. There are some very serious consequences if you fail to comply with the subpoena without a reason. So usually they would just be asking you to produce documents to the court. So anything that you have on your file about a certain person or a certain child, and they usually give their date of birth. There may be a specific list of things that they're asking for. You can ask for conduct money. So that's like money to comply with that subpoena, because there may be staff involved in collating that information and photocopying it and providing it to the court. If you are required to actually appear in person at a court event, you can also ask the cost to attend. So you may not be able to work for a day, for example, you can ask the cost for that. But yeah, as I mentioned, there are serious penalties if you don't comply. There are some grounds that you can object to compliance with a subpoena, but there's really strict time limits in place. So when you receive a subpoena, there'll be a notice on the back that talks about what grounds you can object on and how you need to do that. So if you're not planning on complying with a subpoena, my advice would be to get legal advice very quickly and prior to the production date, and then making sure that any objection is filed in time so that the parties and the court know what you're planning to do. I wouldn't recommend just leaving it to see if anyone's going to do anything about it. And there's quite limited grounds that you can actually object to a subpoena on. The usual ones we see are if the material is irrelevant to the parenting proceedings, or if it's a very broad subpoena, which makes it hard to narrow down what you're needing to provide. Generally, in parenting matters, parties will be subpoenaing a counsellor for notes about either the parents' sessions or the child's sessions, including, when they've gone, what sessions have been cancelled, and then notes about what happened during the session and any communication between a parent and the counsellor or the office, for example. So the other way that you may be asked to provide information is directly by a parent or a lawyer, where they say, hi, you've been seeing Susie, we're having a family law dispute, can you do a report about how you think she's going or what her current diagnosis is or something along those lines. So that's voluntary. I guess you're not required to comply with that request. And then what sometimes happens if you say no to that is that they then go issue the subpoena to get the information that way. So I guess before you agree to do an affidavit or a report, you should be aware that that does potentially make you a witness in any final hearing that may come along. So you may be giving a written report now, and you may be happy to do that and attach it to an affidavit, but in 6 or 12 months' time, when the matter goes to a trial, you may then be required to come along and give evidence and be cross-examined about your report and how you came to those conclusions and things like that. So I guess it's not necessarily a one and done kind of thing. You might have to then carry through with other things that are going on in the matter. Obviously, the big thing that comes up is counselling notes and them being subpoenaed. So there was recent state-based legislation in Queensland that protects specifically records in relation to victims of sexual assault or alleged sexual assault from being used in some courts. So that relates to criminal and civil proceedings from, I think, the 1st of December 2017. So that would cover domestic violence proceedings as well. And there is a particular pro bono service, the Counselling Notes Protect service, which give advice about that. So if you have notes around sexual assault, being a victim of sexual assault, there may be a further exemption as it relates to criminal and civil court proceedings. And you can contact that service to get advice about that specifically. In that context, so in the context of this state-based legislation, counselling is given quite a broad definition. So that's really talking about counselling in the sense of like providing advice and encouragement and help to someone, as opposed to needing to be any kind of specifically registered list of counsellors. And those counselling records are protected from being available during a court or from being subpoenaed. But again, the legislation only covers those matters from the 1st of December 2017 onwards, and that's not the same as the family law exemptions that we spoke about earlier. So that's more generally for the state-based legislation, which is criminal and civil, including domestic violence, rather than the federal legislation, which covers the family court side of things. So again, it's one of those things where, as you can see, there's a lot of grey areas and there's a lot of crossover with different exemptions and things. So just something to keep in mind and get that specific legal advice if you do have these issues coming up. Okay, so that's covered off, I guess, some of the general evidence-based stuff that comes up for counsellors. We'll have a bit of a chat about parenting arrangements and how that works and stuff that you guys might be seeing in practice. just to cover off generally what the legislation says about those things and the terminology that you may see coming across. So parenting arrangements can come about in, I guess, 3 different ways, and that's usually the ways we see. So there may be verbal agreements between parents where they've just said, let's do this and we'll see how it goes, or they may change it week to week. The second way is for a parenting plan to be, which is a written document signed by both parties. As I mentioned before, that doesn't need to be a specific format necessarily, but that's often what comes out of a FTR. And then also we've got consent orders or court orders. So verbal agreements are usually in place where parties are fairly amicable after separation, or where sometimes that's the better option if kids have high needs, or if there's other issues going on with the family. It may be just too difficult to work out, particularly in that transition phase after separation. So parties may just put in place a verbal agreement and work together to try and get that to happen until they can get something more formal, or they may never get something more formal. So for that to work, it really requires the parents to have quite a high level of communication, because they really need to be talking pretty regularly about what's happening in any particular, week or day. So again, it requires parents that are able to really put the children's best interests first. That can be really hard for people, particularly in that period after separation. Sometimes, people are often emotional. Parties may blame one parent. Parties may not be able to really focus on the kids during that period. So it can be difficult. These clients are often not, I guess, the people that end up seeing us as family lawyers, because often they have gone away and done their own thing without needing that legal advice. So it's a bit of a different category, I guess, to clients that I see day to day. And I guess the benefit of it is that it does allow that flexibility with the parenting arrangements that you may not necessarily have if you've got something in writing. A parenting plan is where the care arrangements are put into a written agreement, signed and dated by everyone, made without either party being under duress, but there's no particular format to it. Again, a parenting plan can be quite flexible because it's not a court document. There's not really any restrictions on what can be included in that document, and there's not necessarily any jurisdiction issues with the court not being able to make certain provisions. So it can be flexible, it can cover off a range of things, and it can be really tailored to the children that are involved. There's a minimal cost, I guess, to that if parties are able to sit down and do that, or if parties are able to do that at FTR. It is something lawyers can get involved with drafting if they need to, or with the negotiation side of it. But I guess there's nothing stopping parents from sitting down and drafting their own parenting plan. A parenting plan is not binding and enforceable, which is sometimes where this falls down with parties if they are quite high conflict. So it provides evidence of what the intention was at the time and what those parties at the time thought was best for the kids when they signed it. But you can't take a parenting plan to, the police or to the court and say, oh, he's breached the parenting plan, because it's not binding and enforceable in that way. So it's good because it provides a level of formality and a reference document for parties to look back on and say, if there is a disagreement, they might say, okay, well, let's go back and look at what the parenting plan said. So it can provide just that level up in formality to give them a reference point. But if you've got very high conflict parents or there's significant issues with the parenting arrangements, then it may not be the best option. The next option obviously is to do consent orders. So this is something you guys probably see a fair bit in practice. So often parties will give copies of orders to counsellors and medical practitioners and things like that. So there's 2 ways you can get to a court order. Either it's by agreement, which is what we call a consent order, and at the top of a consent order it would say the parties consent to orders in these terms or something. So it would say that they've consented to it. That's different to the court that has making an order after a final hearing. So if the court has heard all the evidence and made an order, then the court imposes those terms on the parties. A consent order is made by both of them agreeing on something. So again, parents can negotiate consent orders between themselves or with the help of a solicitor, but it's obviously a lot more formal in terms of the format of it and what forms you have to file. It gets filed with the court, and the court seals that order and sends it back to the parties. It then becomes a formal document. So once an order is made, it can only be changed if the parties agree on something else down the track and consent to that, or if they actually go back to the court and ask the court to make it. So in that sense, it's a lot less flexible than a parenting plan, because technically a consent order is in place until children turn 18. Unless the parties agree on something else outside of that, or unless the court says it's no longer needed. So if you've got very high conflict parents that have got a court order and a child is, say, 5 years of age, and then the child turns 6 and mum says, I want to change the order, dad says no, technically that court order that's already there will just tick along until there's some other change, or until the court says that it is best for the children to change it. So it's a lot more inflexible if you do have parties that aren't going to be able to agree and maybe aren't in that position where they are going to be able to be child focused about the arrangements. So parental responsibility is something that you've probably seen if you do come across lots of court orders or parenting plans. So parental responsibility is, I guess, talking about parents making major long-term decisions for children. So under the Act, there's a presumption that both parents have equal shared parental responsibility for this decision-making power. So that's where we're talking about things like religion, what school children go to, what name a child is referred to by, any health issues, and where a child is living if it impacts the other parent's time. So that's where we start looking at, I guess, long distances, if a parent's planning to move a long distance away from the other parent. So those long-term issues should be made jointly by parents, and if they can't be made jointly, then the court will need to make a decision about what they say is best for the children. Those kind of decisions are very different to day-to-day issues where the court says that parents are able to make those day-to-day decisions generally, unless there's, I guess, again, unless there's an exemption or unless there's a really unusual or particular situation with the child, then those day-to-day decisions are made by the parent that has the care of that child. So that might be things like what they wear to school, what they're eating at, what gets packed in their lunch bag, whether they go to soccer or not, if they've got a cold, those kind of day-to-day things that parents just can't, I guess, communicate day-to-day about. But the long-term issues is where the parents need to be making a joint decision. Having equal shared parental responsibility is not the same as having equal time with a child. So that's something I guess we see a lot, that parents get confused. They see that the legislation says it's presumed that parents have equal shared parental responsibility, and then they say, well, that means I get 50-50 or I get week on, week off with the child. So it's not the same concept. This really just relates to the decision-making power. Again, there's always an exemption to these things. So the presumption is that they have that equal shared parental responsibility, but that presumption is rebutted if there's issues of family violence and where it's not the child's best interest for the parents to share those responsibilities. So there's always that exemption that operates. So as I mentioned before, when we're talking about what you may need to be telling parties about if they're coming to see you for counselling or FTR, the paramount principle and the paramount consideration for the court when they're looking at a parenting matter is what's in the child's best interest when they're making any parenting order. So the court looks at through, I guess, levels of considerations. There's the primary considerations and the additional considerations. Both of those are set out in Section 60cc of the Family Law Act. So again, that's quite a good section to have a look at because often we hear clients say, oh, well, what about he's now 13, he can make a decision, or what about, she doesn't want to go spend time there. So there's different things that come up. Section 60cc lists out the considerations that the court has to take into account. And so you might be able to point to a client and say, well, that's one of the factors, but that's not all the factors, and the court still has to have a look at what this best interest paramount principle is. So I guess that's the framework that the court use when they're making a decision about parenting arrangements. And again, it's all about directing people to be best interest and child focused when they're looking at what parenting arrangements are. So the two primary considerations are basically the benefit to the child of having a meaningful relationship with both of their parents. And then again, there's also this kind of overarching consideration of any need to protect the child from physical or psychological harm and family violence. So unfortunately, obviously, in some situations, it may not be a benefit to the child to spend time with the other parent, for example, if there's these really serious risk issues involved. So the court has to kind of overlay that on a case-by-case basis in each particular situation. These are some of the additional considerations. As I said, they're set out in that section 60cc. So the views expressed by the child or the children, taking into account the child's maturity and understanding, that's something that often people bring up as a reason why there may be a parenting dispute. The nature of the child's relationship with each of their parents and any other extended family, the extent that each parent has taken previously to participating in those decision-making, spending time and communicating with the child, the likely effect of any change in circumstance for the child, including separation from a parent or relative, and then any practical difficulties of spending time and communicating and the expense of that. So that's some of the additional considerations. The other ones are parents' capacity to provide for a child's emotional needs, maturity, sex, lifestyle and background of the child and the parents that may be relevant, as particular consideration given to if a child is Aboriginal or Torres Strait Islander and ensuring that they have that connection to culture. If there's been any family violence, looking at those orders, what the circumstances of those orders were and how that evidence may be needed to be considered in the parenting discussion, whether an order should be made that will be least likely to lead to further proceedings. So the court really, I guess, wants to see that if it has needed to be determined by the court on a final basis, then they don't want parties coming back every 6 or 12 months because they don't like it or because they say something's changed. So it's really about trying to make sure that any orders that are made don't lead to further litigation, because that ultimately doesn't usually give good outcomes for children or for parents. And then there's this general kind of any other fact or circumstance. So the court has quite a broad discretion to look at whatever matters they think might be important and relevant in a particular situation. So generally, and I guess again, this is something you would see in orders or parenting arrangements when you have it. So usually the wording would be something like, the child is to live with the mother and the child will spend time with the father as agreed and failing agreement, and then there may be a provision for whether it's week about or 5 nights, alternate weekends or something like that. So that's the wording that's in the legislation. We don't use custody anymore. We use a live with parent and a spend time with parent. That's the wording that we use. So that's what the orders will provide for. So there'd also usually be provision for some school holiday time. Special occasions are usually spelled out. So what time a child is having Christmas, Easter, Father's Day, Mother's Day. Overseas travel, I guess, has been a bit of a less of an issue than usual with COVID over the last 2 years nearly, but still we'd be putting that in orders because hopefully that's something that we'll be able to do again. So things like who's keeping passports, both parents signing passport applications when they're coming up and things like that. And then anything else that we can think of that may come up. So some of the stuff that might be included is if the parties have agreed on what high school they're going to, if they're not at high school as yet, if there's other, step siblings' birthdays or family events or something that may be up. So there's just a few different things that, depending on the particular situation, that may be included. Obviously, ideally, parents are going to be agreeing on these things because parents know the children far better than lawyers or, a family report writer or the court can know. All lawyers and the court can do is look at the evidence they've got and try and work out what's best for the children. But ideally, in any situation, it would be the parents that are agreeing on that and getting a consent order. So court's really a last resort for these matters. So this is, I guess, where people do sometimes get confused between that presumption of equal shared parental responsibility and what time that means. The legislation does have an obligation on the court. If there is that presumption of equal shared parental responsibility, the court has to then look at whether equal time with both parents is in the best interest of the child and whether that's reasonably practicable. So having a look at, child's wishes, how far apart the parents are living, where do the kids go to school, where, who's working, who can do pickups and drop-offs, all that practical stuff. If that's not appropriate, then we start looking at significant substantial time and whether that's best for the child and whether that's reasonably practicable. That generally means that the parent who doesn't have the children the majority of time is having time on both weekends and weekdays and holiday time and being able to be involved in all those different aspects for a child. If that's not practical or if that's not best for the child, then the court has the discretion to make whatever orders they think are in the child's best interest. So I guess that's how it may be broken down. You probably won't see that wording necessarily in the orders that you're seeing, but if, for example, it's living with dad most of the time and mum's got 5 nights a fortnight, then that's a substantial and significant time arrangement. And they're all the things that you might want to consider when you're looking at reasonably practical and how that might impact the children. This is something that I guess we as lawyers hear a lot, and probably you as counsellors would hear when you do start dealing with parents or children that are from separated families is when does my child get to decide where they live? There's no set age under the legislation when a child can say, oh, but I want to live with mum or I want to live with dad. So often we hear, and it's a bit of a myth out there, that it's 12 that children can choose. That's not the case. The section really just says it's one of those factors to be taken into account, and even then it depends on the child's maturity and how firm those wishes are and how they're expressing those wishes and how that's come about. So I guess we can look a little bit to some the International Convention on the Rights of the Child. So it is something that needs to be taken into account. Obviously, the older and more mature a child is and why they're expressing those wishes, it's going to be given greater weight by the court as one of those considerations. There's a very different, I guess it's very different if you've got a 5-year-old saying, I want to live with dad, and when you look into that, it's because, dad might have a PlayStation and mum doesn't, and that's kind of where a 5-year-old may make that decision. That's a very different argument to when you may have a 13 or 14-year-old who's expressing a wish who may have other reasons for doing that. So that's why we need to look at the age and maturity. A very mature 10-year-old may be given more weight than a more immature child who's older or who may have learning difficulties or something and doesn't have the maturity or understanding to make that call. So that's why it's a case-by-case thing. There's no age. And it can create quite big problems if people have said to their children, oh, when you get to your 12th birthday, you're going to be able to make that decision. So it's just something to be careful of if you are having those discussions with people as well. So I guess it's not something necessarily that the children will be able to voice directly to the court either, and that's something that can also create problems. So there's certain ways, and we've got to have certain support and scaffolding around how those wishes come out in family law proceedings. Often, obviously, the parents may say, oh, well, Johnny told me this or that, and that may be put into an evidence by that parent or a grandparent or something who's heard it directly from the child. Judges can speak to children directly, but it's very, very, very rare in Australia. So I haven't ever had it happen on any of my matters. I've been in the back of court once where the judge asked to speak to the child, but that child was 16. So that's, I guess it's a bit of a maturity and a depending on the situation call, but it's not very common in Australia for that to happen. Independent children's lawyer, as we spoke about before, that's someone that is there to act not necessarily for the child, but for the child's best interest. But they do occasionally speak to the children, again, depending on the age. But the real, I guess, the more independent way we would usually get that evidence before the court would be through a family report or a family consultant having those discussions with the child and doing a written report to the court, and then often also giving verbal evidence about what they've heard and what the discussion was. So that's how usually that information would come before the court. as I said before, the weight to be given to a child's wishes is really where it varies. So it's just one of those Section 60cc factors, and the weight to be given to it will usually depend on the maturity and all of those other things, how strong that wish is, whether there's a rational base for them having that, or whether it's been influenced or coached by a parent or some other person, and then also looking at what impact will it have on the child if their wishes are followed or if they're not followed. And again, that often comes down to, you know, their age and maturity. If you've got, you know, a 15-year-old saying, I want to live with dad, what's the impact going to be on that child and on their, you know, self-determination and their ability to make those decisions moving forward if it's not followed by the court. So yeah, I guess the takeaway from that is parents hopefully aren't telling their kids that they're going to be able to make a decision at some point, but it's really, again, it just depends on the particular circumstance. So it would be very hard to say at what point a child will be able to do that, because it's really a case-by-case thing. So the court, just a little bit about the court process and what happens if you are involved in court proceedings, or if you've got clients involved in court proceedings. So one of the parents generally files an initiating application along with an affidavit which sets out their kind of version. And there's some other supporting documents. So as of the 1st of September, those have changed. So you've got to file a parenting questionnaire, you've got to file a genuine steps certificate, and there's a notice of child abuse or risk, which notifies the court if there's any urgent domestic violence or risk issues. Prior to filing, there are new pre-action procedures that people need to follow. So we spoke before about the Section 60I certificate, so that's still there. Parties need to have attempted FDR unless there's one of the exemptions. And there's also a pre-action procedure. You have to kind of, I guess these new rules as of the 1st of September are really focused on parties resolving matters or resolving as many issues as possible before they get to court, and then really focusing on that when parties get to court. So it's really this resolution focused system that the court's trying to work towards to try and get people to make their own, I guess, decisions about particularly parenting matters before they get too far in the court process. So as part of that, you know, you need to write to the other side and say to them what your position is, put a proposal to them to try and resolve it without going to court, and also invite them to attend that FDR session if that's appropriate. And again, this is all caveated on not having those domestic violence or other urgent issues that we spoke about before. That gets filed, the court would give you a date, and then those documents get given to the other side, and then the other parent does the same kind of thing. They file a response, they file their affidavit, they give their version of events, and then there will be a court date, and then it kind of ticks along the court process. So most matters, although you may need to file in court, don't actually get all the way through to a final hearing at court. 90 to 95% of matters resolve at some point along the way. And that's partially, I guess, due to the court having a lot of processes in place to try and get people to resolve. And also, I guess, just the evidence that may come out which might help parties resolve, or the report that may be given as part of the proceedings that encourages people to resolve. So once the matter's in court, the court does do a lot to try and progress things and get people on the same page and try and resolve any issues that might be there. So parties are usually ordered to participate in a child impact report. So that's like a short form report prepared by the court child expert to provide a summary of issues. That's part of these new rules that have come about. So that's usually done quite quickly after the first court date, or even sometimes before the first court date if they're in the EVIT list, was a specialised DB list. So that's done, and then the court will generally encourage and push people towards an FDR. So that report hopefully will help the parties either narrow the issues or come to some kind of agreement on some of the issues. Then you're off to an FDR. Under the new rules, that's supposed to happen within 5 to 6 months of the matter being filed in the court. Depending on how that goes, the court may decide they need a bit more of a detailed report about the family situation and the children, and that's when you might go off and get a family report, where that's more of a long form report where you've interviewed parties, you've observed the children, and that gets given to the court as well. And then, as we mentioned before, depending on the age of the children, the family report is that opportunity that the kids may need to talk to the family report writer. The people doing these reports, I guess, are, you know, counsellors, social workers, psychologists who ask these questions in an age-appropriate way and ask the questions to get the information they need about that. So, yeah, as we mentioned, for family court merger, as of the 1st of September 2021, so there was a fair bit of media around the merge and the bill that was going through Parliament to get the merge to happen. So previously we had the Federal Circuit Court and we had the Family Court. Very creatively, they have merged it and called it the Federal Circuit and Family Court. So they haven't done a lot with the name, but I guess it's gone from being two separate courts to one court, and there's kind of two divisions to that court. So, I mean, it's not a huge structural change. I guess the rules are really where a lot of the changes have come in. So the, I guess, purpose behind the merge was really, there was a lot of delay, confusion, and additional cost, additional court dates, and previously they had different court forms and slightly different processes depending on if you're in the family court or the Federal Circuit Court. So that was particularly confusing for parties that were trying to navigate the system without the benefit of legal advice, because it was very hard to work out, you know, which form was for the family court and which was for the federal court. So they've made it all one court, they've unified, they've harmonised the rules, and now we've got this common set of rules and procedures in place. They still have two divisions. So Division 1 deals with matters that were previously dealt with in the family court, so that's your more complex matters, and basically the judges that were family court judges have gone to Division 1. The Division 2 matters is where, you know, 99% of family court matters are dealt with, which used to be the Federal Circuit Court, and that's basically the judges that were the Federal Circuit Court judges have gone to the Division 2. So the real change is that I guess we've got these common set of rules. There's a single point of entry. So previously you kind of had to look at the family court and the Federal Circuit Court and try and work out which court you should file in. Now everyone files in the Division 2, which is the general family law division, and then the court themselves actually triage matters and work out if they do need to be sent to Division 1, or the registrars or the judges will do that throughout the process. So that's simplified things. Everyone files in the one point and everyone's got the same forms and processes and procedures in place. So that's the little bit of a summary of the family court merge. Just to summarise where we're at and some tips for you guys if you're working in the area and counselling people who are involved in these things. Default position in terms of counselling and notes is that it's not confidential. So I guess work on the basis that if you are subpoenaed, you would be required to produce those things. So when you're looking at note keeping and what you're keeping on your files, I guess you've got to assume that a court may be looking at that at some point. So really think about what the purpose of your note keeping is. Avoid making, I guess, general comments or opinions when you're writing notes, and really documenting the facts. What did they tell you? What dates did they come to see you? You know, who contacted you with the appointment? All of those things. The interpretation of confidentiality and admissibility, as we spoke about, it's still quite unclear. There are the provisions in the Family Law Act, but there's also a lot of exemptions, or there's different definitions for things. So it's not as clear cut as saying yes or no. So yeah, assume your notes can be subpoenaed and assume that you can be compelled to give oral evidence. And then seek advice from your own professional bodies about note keeping and responding to subpoenas. But as I said, if you get a subpoena, you must respond to that in some way, whether it's objecting or whether it's asking for, you know, more information or something. Don't just ignore those, because they are court documents and there are penalties if you're not complying with those things. I would encourage people, if they're having these family law issues, even if things are amicable, to be getting advice from a family lawyer in private practice, or there are quite a few amazing community legal centres in Brisbane as well. So there's a few there. There's a whole list of services around Queensland that provide community legal service, which is free legal advice. Most of them are one-off sessions, but if you've got people who are just wanting a bit of information, or they're wanting to talk about what they should be putting in a parenting plan or something, then those services are fantastic. Otherwise, obviously reach out to a private practitioner if they need that more tailored and specific advice. These are some of the other things, I guess, that we deal with day to day, and I'm sure that you guys have experience with as practitioners as well. If you do have any questions, the email address on the slide here, so it's just law@nlynch.com.au. Feel free to flick any questions through and we'll do our best to answer those after today. As I said at the start, we do have that fixed fee initial consultation fee. So if you do have clients that want that private advice, feel free to get in contact with us and we can help out. But otherwise, the email address is there, the website is there. We've got a whole lot of brochures on the website. The new court website since the merge has also got a whole bunch of really good resources as well. So when they've done the court merge and the new rules, they have updated quite a few of their brochures, and there's some videos on there as well. So that might be another good resource to look to if you're just wanting some general advice. So that's all from me today. I hope that was really helpful. Thank you so much for tuning in. And if you, do have questions, we'll wait to hear from you. Thanks.